Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of proposed rulemakings under Dodd-Frank, Wall Street Reform and Consumer Protection Act. It will be regarding position limits for physical commodities, which is the pending business before the Commission, and swap trading relationship documentation requirements for swap dealers and major swap participants. Before we hear from the staff, I'd like to take, though, this opportunity to congratulate Commissioner Mike Dunn on his 25 years of service to the federal government. Mike is a trusted colleague who works incredibly hard in service to the American public here at the CFTC, but he also served at the Farm Credit Administration, the Department of Agriculture, the Senate Agriculture Committee under Senator Patrick Leahy's chairmanship, and probably a few other places, because he's been nominated by presidents of both parties and confirmed by the U.S. Senate, I think it's 6 times. And having done that myself a few times, 6 is really, that's something to be noted. So I'm honored to work with Mike and call him my friend and colleague. I want to present him actually with a plaque, if that's all right. But this is his 25 years of service plaque.
Thank you, Mr. Chairman.
You want to hit your mic if you want to.
Thank you very much, Mr. Chairman. This is an unexpected pleasure. And I must say, the 25 years of service in federal government, and that even goes back to some time starting with Lyndon Johnson to today. So I've earned every gray hair that I have. But the most amazing thing that I have found in my tenure working the federal government was the dedication to the men and women who are known as the Civil Service Corps. It is too often in the press today that folks have said the government is the enemy or is the problem. And then it's shifted not from the government, but for the men and women who work day to day in government as a problem. And that's just simply not true. I think all of us, in the 25 years that I have in, I've never been a career civil servant. It's always been in an appointed position. That's pretty amazing. Some people may say I've managed to fool a lot of folks. But the reality is that working with the career civil servants has been an honor for me, and the 25 years that I have in, the successes I've had are a result of the great support we've had with those staffs. Failures, I have to put those on my shoulders, but thank you all, and thank you, Mr. Chairman, for presenting me with this plaque. I'm honored.
Thank you. No plaques, but I do want to thank Commissioner Jill Summers, Commissioner Bart Chilton, who's joining us by phone. I hope, Bart, you're on, and Commissioner Amalia for all their thoughtful work on implementing Dodd-Frank. I'd also like to just make, this is a personal moment, to honor somebody whose birthday would have been today, and that's my wife. We lost Francesca about 5 years ago, but our 3 daughters and I miss her dearly. She was a beautiful woman. And I can't help but thinking about her today because it was her birthday. I will return now to the business of today's meeting. Welcoming members of the public, the market participants, members of the media to today's meeting, as well as those listening by phone and watching on webcast. This is our 9th public meeting to consider rules with regard to Dodd-Frank rulemaking. Our next meeting will be January 20th. We'll also schedule some additional meetings in February. I think we'll take up the dates of those meetings at our January 20th meeting. We'll set some dates for those meetings. As we have been doing, we'll announce the actual rulemakings that we'll consider 1 week before the meetings. Staff's worked very hard on the rulemakings that the Commission is considering today. They'll present the recommendations. Of course, position limits is the one that's in front of us. So I think we'll just be probably taking some questions for the staff on that. And we, of course, continue to look forward to receiving public comments on all the rules that we put out, and there'll be questions and answers on these rules posted on our website. Before I turn it over, I turn it to my fellow commissioners for their opening statements. Commissioner Dunn.
Thank you, Mr. Chairman. Thank you all for joining us today in this important meeting regarding the implementation of the Dodd-Frank Act. Today's meeting will address proposed rules regarding position limits for physical commodity derivatives and documentation requirements for swap dealers and major swap participants. The Commission is required pursuant to the Dodd-Frank Act to set position limits as appropriate to diminish, eliminate, and prevent excessive speculation. There has been the suggestion by some that once we set position limits on physical commodity derivatives, the price we pay for gas, bread, milk, and other things will inevitably drop, and that volatility in the commodities market will simply cease to exist. I believe this is a fallacy. Price volatility exists in markets that have position limits and in markets that do not have position limits. Price volatility exists in markets that have substantial participation from index funds and markets that do not have index fund participation whatsoever. As Nobel Prize-winning economist Paul Krugman pointed out in a recent editorial, price volatility exists in our market because we live in a finite world where there is not, at any given moment in time, an inexhaustible supply of oil, wheat, milk, or other physical commodities to meet the global demand for such products. Simply put, sometimes prices are higher because the demand for products around the globe is greater than the supply. Since these are global commodities, the demand driving higher prices might not even be from U.S. consumers, but from a growing middle class in countries with emerging economies. Mr. Krugman does point out that this doesn't necessarily mean that speculation plays no role. With the passage of the Dodd-Frank Act now clearly as a mandate to set position limits on commodity markets and the over-the-counter markets as appropriate to diminish, eliminate, or prevent excessive speculation. To date, CFTC staff has been unable to find any reliable economic analysis to support either the contention that excessive speculation is affecting the market we regulate or that positions limits will prevent excessive speculation. The task then is for the CFTC staff to determine whether position limits are appropriate. With such a lack of concrete economic evidence, my fear is, at best, position limits are a cure for a disease that does not exist, or at worst, it's a placebo for one that does. I am voting for the proposed rules on position limits in order to gather more information. If there is more than anecdotal evidence that there is excessive speculation distorting the prices in our markets, we need to see it. If there is statistical or economic analysis that shows that excessive speculation exists and that position limits will diminish, eliminate, prevent it, we need to see it. If there is evidence that position limits will lower the price we pay for gas, milk, and steak while simultaneously ensuring the integrity of our market and price discovery process, we need to see it. Only after these questions have been answered will I be able to determine whether or not position limits are appropriate. If we determine that position limits are appropriate to diminish, eliminate, and prevent excessive speculation, I think we must then work with our sister regulators around the globe to ensure that limits set here in the United States markets are not simply evaded by trading in other venues around the world. Lastly, I would like to speak briefly about the budget crises facing the CFTC. The CFTC is currently operating on a continuing resolution with funds insufficient to implement and enforce the Dodd-Frank Act. My fear at the beginning of this process was that due to a lack of funds, the CFTC would be forced to move from a principle-based regulatory regime to a more prescriptive regime. Now, if our budget woe continues, my fear is that the CFTC may simply become a restrictive regulator. In essence, we will need to say no a lot more. No to new products. No to new applications. No to anything that we do not believe in good faith that we have the resources to manage. Such a restrictive regime may be detrimental to innovation and competition, but it would allow us to fulfill our duties under the law with the resources that we have available. Again, I would like to thank the staff of the CFTC for all the hard work in regards to these very important proposed rules.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. Good morning, and I'd like to start again today by thanking the teams, both of the teams that we have before us today, for all of their hard work on the proposals we're considering. I know that Sarah Josephson, who's the team lead for the internal business conduct standards, has been before us on a number of different occasions, and this is the last proposal for her team, and just want to thank all of them for all their hard work on the proposals that we've already put out and the one today, and also to the position limit team, who's also been before us on a number of different occasions. I want to thank all of them for their perseverance on these very difficult issues surrounding position limits. I will be supporting the swap trading relationship documentation proposal today because I believe this documentation is a critical component to well-functioning swaps markets. The documentation increases transparency to the regulators and increases certainty among the counterparties, both of which are vital. Regarding the position limits proposal, let me say at the outset that while I opposed the Commission's 2009 proposal, and I oppose this proposal today, I do not have a per se philosophical opposition to position limits. I understand that Congress has directed the Commission to implement position limits as appropriate. If we had a reasonable and enforceable position limit proposal before us today, based on analysis of complete market information, I would support it. We have not in the past, nor do we now have such a proposal before us. I opposed our 2009 position limit proposal because I thought it was a bad idea to impose position limits on exchange-traded contracts when we had no authority to consider limits on the vastly larger over-the-counter markets. I believe that had we imposed limits solely on exchange-traded contracts, we risked driving market participants out of our regulatory purview and into the opaque over-the-counter markets or overseas. This would not have been a positive regulatory outcome. I oppose the proposal before us today because I believe it is flawed in a number of respects. First, I believe we should conduct a complete analysis of the swap market data before we determine the appropriate formula to propose. We have not done that. Second, without data on swap market positions, the spot month limits we are proposing are not enforceable. I think it's a bad policy to propose regulations that the agency does not have the capacity to enforce. Third, in Section 4A.A.1 of the Commodity Exchange Act, Congress specifically authorized the Commission to consider different limits on different groups or classes of traders. This language was added in Section 737 of Dodd-Frank. The proposal before us today does not analyze or in any way consider whether different limits are appropriate for different groups or classes of traders. Finally, Section 737 of Dodd-Frank states that the Commission shall strive to ensure that position limits will not cause price discovery in the commodity to shift to trading on foreign boards of trade. This proposal does not contain any analysis of how the proposal attempts to accomplish this goal. In fact, the proposal does not even mention this goal. Driving business overseas is a long-standing concern of mine, and that concern remains unaddressed. Position limits has presented and still presents a number of different challenges for this Commission, but I believe strongly that the proposal before us today still misses the mark. Again, thanks to the two teams before us today and your enormous efforts in helping us get these proposals out Thank you.
Thank you, Commissioner Summers. Commissioner Chilton, I believe, is on line.
Yeah, I'm here, Mr. Chairman. Thank you, and thanks to the staff. I support both of these rules. I do have a statement that I'd like to have included in the record. It's short, without objection, Mr. Chairman. And I would also like to congratulate Commissioner Dunn on his long service. I've had the pleasure of working with Mike and following Mike at different places in the Senate and at the Farm Credit Administration, but also working with him at USDA. And I'm pleased that most of the time we've been on the same side of issues, and that really makes me comforted, and I've known that I'm doing the right thing a lot of times. We don't always agree, and we both, I think, are supporting the position limit rules, but for different reasons. And the only comment I'd make about that is that the as appropriate language in there, I don't think Congress ever intended that was to be interpreted with such elasticity that it meant that we could say nothing is appropriate. I think it means we have to do something. It's just figuring out the right level. And maybe my colleagues don't disagree with that. But either way, we'll see how things go forward, and I support both the rules. And I thank everybody for their work on this and congratulate Commissioner Dunn.
I thank Commissioner Chilton for following behind and cleaning my messes.
Thank you, Commissioner Chilton. Commissioner Amalia.
Thank you. I'd like to also extend my congratulations to Commissioner Dunn for 25 years of excellent, outstanding service. He's done a great job, and I've enjoyed working with him in the short time I've been with him, and I enjoy being such close suite mates upstairs, and I can always rely on his counsel, and I appreciate that, and his advice is always well appreciated. Thank you. Congratulations. I believe that releasing the proposed rule for position limits for physical commodity derivatives for comment in its present form while simultaneously implementing a separate position points directive is an attempt to set position limits that is inconsistent with the language and the purpose of the Dodd-Frank Act. I believe that the proposed rule and the supplemental directive will create uncertainty regarding the regulatory standards for the Commission action and enforcement in a way that does not comply with the Administrative Procedures Act. The uncertainty that will result from the publication of both the Commission proposed rule and a possible attempt to enforce position points proposal will stymie the ability of market participants and specifically large commercial interests to manage their hedging and investment strategies. Semantics and affirmations of intent will not lessen the real impact of what essentially amounts to an attempt to affect legal rights and obligations. The new position points proposal operates as a Trojan horse by attempting to articulate a requirement of general applicability without providing the opportunity for public notice and comment as required under the Administrative Procedures Act. If setting federal accountability levels is the preferred course of action, then it should be embodied in a proposed rule subject to notice and comment under the APA. That has never been an option put before me and is not the rule in the rule today. With regard to the proposed rule for position limits, I appreciate the fact that the comprehensive changes to this rule have been made, including two important reforms. The first change has been the removal of the onerous crowding out provision and instead looking through the dealer and applying position limits to the actual customer. Any customer conducting bona fide hedging would not be limited by this position limit proposal. Second, the rule provides that no position limit will be set until the Commission has the data to monitor and enforce such limits, and only those can be effectuated through a future Commission order. This begs the question, how can the Commission decide to impose proposed limits on swaps positions without having the facts or understanding the impact on the market? Without the actual data, we have no idea as to the impact on liquidity or excessive speculation as a result of these limits. I hope that through public comment period, we will develop a better understanding of whether or not these proposed limits are appropriate or if they should be changed. Further, if the Commission is going to proceed with implementing limits, I hope that the supporters of the position limits will provide relevant data and evidence to demonstrate that position limits will stifle the upward pressure on prices in the markets as they have stated in their previous comments. I'd like to thank the staff for their efforts. They've been through this ringer a couple of times, and they've done a great job to respond to the Commission's concerns. Mr. Chairman, you and I have spoken this morning about position limits. I don't object to the staff collecting data. That's their job, and they do it every day, and they do it very well. I do expect that they will also inform the Commission as to the applicable hedge limits in their investigation of the positions at your direction. I do object to taking any action to enact these position limits proposals outside the appropriate rulemaking process, however. I will ask a number of questions to the staff regarding the implementation of the position points proposal, and we'll make my decision based on that. Thank you.
Thank you so much, Commissioner O'Malley and all the commissioners. I think consistent with our other public meetings, the staff is here to present proposals. Of course, with regard to this group, it's the pending action. So I think that taking up where we left off on December 16th, there's currently a motion pending on the floor to accept the staff recommendations while the proposal remains the same. The staff has taken the last month to make some technical changes to the proposal, so I first just ask unanimous consent to adopt the substitute proposal that contains those technical changes. Without objection, so ordered. In terms of actually voting on this, I suspect there's going to be some additional questions, so I open it up, I guess, first to Commissioner Dunn if there's additional questions.
This is in essence the same motion we had before us at the last meeting.
Yes, that's correct.
Thank you. With that, Mr. Chairman, I'd like to ask you a few questions, if we could. Mr. Chairman, I'd like to further understand the direction you gave the staff about surveillance at our last meeting. Is your direction to staff consistent with what staff currently does?
Yes, it is consistent. For decades, the Commission surveillance staff has briefed the Commission weekly on the positions of traders in futures markets that are of regulatory interest. Sometimes this regards large traders, price volatility, supply and demand imbalances, issues around delivery in the spot month, or even around convergence matters. In that regard, staff currently monitors large traders in these markets. Specifically, what I've asked staff to report monthly to the Commission on is regarding the staff surveillance activities related to traders with positions at or above the 10 and 2.5% level of futures open in the market on the 28 agricultural, metal, and energy markets for which we're proposing position limits.
Mr. Chairman, what are some of the typical activities that they engage in, and what do they do if they have concerns?
Well, staff currently receives information including Form 40s from large traders, and when traders' positions get large, staff familiarize themselves with the business purposes of the traders' use of the derivatives in the markets. This may involve reviewing just public data, confidential market data, or contacting traders directly. When the staff has potential concerns, they may also issue special calls to obtain additional information about traders' cash and swap activity. Ultimately, if staff continue to have concerns, they can recommend appropriate action to the Commission for its consideration.
Mr. Chairman, does this direction given staff in any way implement position limits for the 28 markets covered by this proposed rules on position limits?
No. Implementation of these position limits can only be done in a final rule.
Thank you, Mr. Chairman.
And I'd actually like to ask General Counsel Berkovitz a question. Is there anything in what I've done in directing staff to keep us informed in this monthly way, this information I've asked for all of us, that is inconsistent with the Administrative Procedures Act or any other laws as you know it for the Commission?
No, Mr. Chairman. As you have described the surveillance to be undertaken by the staff, and as Rick described the surveillance that will be undertaken, the surveillance is consistent with current practice, and so this surveillance is fully consistent with the Commodity Exchange Act and Administrative Procedure Act.
Thanks. Commissioner Summers?
I actually don't have any questions with regard to this proposal.
Thanks. Commissioner Chilton?
I don't have any questions. Thank you. I thought the colloquy was helpful.
Commissioner Amalia?
Thank you. I have a couple of questions for General Counsel Berkovitz. The colloquy was helpful. It did clarify many concerns I had. Let me just ask, does the directive from the chairman to staff amount to a commission policy or guidance? And does the staff directive have any binding legal effect on registrants or market participants?
Commissioner Amalia, the directive is a directive to the staff, so that this does not establish commission policy towards registrants or the exchanges. This is a matter of the manner in which commission surveillance will be conducted internally.
Thank you. When might the commission statutory emergency authority give it authority to require a trader to hold or reduce its position below the proposed position points limit? Will the crossing of a position point in and of itself amount to an emergency?
In order to invoke the emergency authority under Section 8A9 of the Commodity Exchange Act, the Commission must find reason to believe that an emergency exists, and that when it finds reason to believe that an emergency exists, the Commission may take such action as in the Commission's judgment is necessary to maintain or restore orderly trading in or liquidation of a futures contract. So there are particular statutory criteria that must be met in order to invoke the emergency authority. Simply crossing a predetermined threshold or numerical level in and of itself, there would have to be additional findings. In and of itself, it wouldn't be sufficient.
Thank you. With regard to privacy concerns, market surveillance generally deals with confidential data. With the position point system, the public is put on notice that at least once a month, a list of names and positions will be presented to the Commission, and commissioners will likely engage in some discussion regarding whether or not any action is necessary. What protections will be in place to ensure that Section 8 material that Section 8 is complied with?
The Commission's normal practice in its surveillance is obviously fully consistent with Section 8, and the Commission does not release any matters that are discussed in the surveillance meetings. These meetings are closed to the public, and the information is protected. So the protections that have been effective in our surveillance meetings will be continued to be applied, and the information discussed in those meetings would be protected from public disclosure.
Can you remind me what the penalties are for violating Section 8R?
I would have to look up exactly the penalties, so I can get that to you.
Fair enough. From a resource standpoint, is the Commission currently in the position to collect and analyze the visibility, position, and related reporting requirements? Maybe I'll ask that to Rick, please.
Yes, because as the chairman said in the colloquy, we do currently gather information about traders, reportable traders with whom we file a Form 40. We're in regular contact with them to have a better understanding of their activity in the markets, and as their positions get large, we would have further discussions and dialogue with them. And our ISS, our surveillance systems do get information on traders' reportable positions, so we do have that information on a regular basis, so it's just a matter of assembling it in a way that's presentable to the Commission to provide that information to them about those traders that have positions above these specific levels.
When you refer to the ISS technology, you're only referring to the data on either the futures market data or related SPITIC data?
Yes,
Significant
the
price
futures
check?
and options, and then the SPITIC, and then foreign boards of trade that have linked contracts.
But swap, by and large, the swap data is
Not included.
not included in that, and we would only be working off of the futures and options related data.
That's correct.
In understanding what what legitimate hedge exemptions apply, is that incorporated in the ISS and TSS database? Is that electronic, or is that a manual effort that we're going to have to bring hedge exemptions and positions together manually, or is that automated?
Well, as you know, there are only 9 commodities subject to federal limits currently. And our process for exemptions involves three types of activities. One is a filing of a form. It's the 04 series form that provides us with the bona fides of commercial traders. Two other types of exemptions are granted by commission staff. And all of those exemptions, and those two other types are of course, for anticipatory hedges and for the risk management exemptions under Regulation 1.47 that are considered bona fide under the existing regulations. All of them, and they're in our integrated surveillance system, the ISS system. As we receive daily reports from the FCMs on large trader positions, our systems pick up that data and we can compare it on a regular basis to that automated system of exemptions.
Thank you. So if we only have 9 contracts with applicable position limits and therefore hedge exemptions, what standard for bona fide hedging will we apply to the other contracts that we'll be looking at in this new surveillance?
We would continue our current surveillance practice of monitoring traders that are very large in the markets, and it wouldn't change our current practice. Because the traders aren't subject to federal limits, and in many cases there are not applicable exchange limits, there would be no hedge exemption provision. They would simply continue to trade as they currently trade.
How will you inform the commission in your monthly surveillance of the relationship with commercial hedging and these position points?
Well, as we had said before, we do gather information from these traders on a regular basis to have an understanding of the nature of their positions, but we wouldn't necessarily be conducting an analysis as to whether each position, looking behind each position as to whether it would qualify as a hedge exemption under the proposed rules. I mean, we would have some idea of the commercial nature of the position or whether it's speculative, but not necessarily making a determination about whether they'd get a hedge exemption. Although they're, having an understanding of the nature of the trading activity might suggest that they would qualify for one if limits were in place.
Well, thank you. Well, it does occur to me that obviously if we're going to be looking at applying a 10-2.5 standard in this proposed rule, then we ought to be cognizant of the relationship to their hedging positions. And
I would say, I think we're going to benefit over the course of these months as a rule is outstanding, because we'll be informed, we'll be able to see some contracts, as you note, have federal limits and some don't, but on the ones that don't currently have them, we'll be better informed as we hopefully address ourselves to a final rule later. All 5 of us will be so much better informed by this monthly briefing of the staff.
Well, I hope we are better informed. I certainly hope the market is better informed about our intentions, and we need to be honest and clear about how we're going to be reacting and treating those market participants going forward, and understanding in the interim period, whether we have a position limits or not, how this will affect them. I guess I'm satisfied that, based on General Counsel Berkowitz's responses, that the position points proposal is not enforceable, and certainly the colloquy with Commissioner Dunn is satisfying as well, and I appreciate you going through that. I'm willing to put out the position limits proposal for comment, as I did in previous rulemakings meetings, but I'm very concerned about how we treat this going forward, and we'll watch this very closely. I would like to say that I have concerns about understanding whether these are the right limits and how they're going to affect it, because we absolutely do not have the data in the swaps market, and understanding how that integrates. And as we are now picking a limit and asking the market to comment on it, we don't have the data to understand how that relates to excessive speculation or position limits and liquidity. So I'm willing to put it out to get the comment, but I'm very skeptical of it.
No, I appreciate that, Commissioner Amalia, and I think that's part of why the proposal has, like all proposals, it's a proposal with a 60-day public comment period, I believe. That will add to the many comments that we had in an earlier proposal, of course. 8,000, I think, in that circumstance. So this will take some time to analyze. And in fact, as you noted, the proposal includes that any numbers would only be ultimately by commission order based on data. I know that Commissioner Summers has some further questions.
I just wanted to clarify something in a question that Commissioner O'Malley just asked with regard to what we do in the normal course of business in monitoring positions. Do we, when we're asking for additional information with regard to a market participant's position, do we usually ask for their OTC positions and cash positions?
I don't know that I would characterize it as usual. Usually is a hard concept because some of these markets are very different, ranging from wheat to corn to crude oil to gold to silver. What we do is try to make ourselves aware of the full range of their business activities. So if they are engaged in a very large position in futures contracts, we will want to know whether they're active in the cash market for the physical commodity, whether that's on the purchase side or the forward sell side. We'll want to know what their inventories are, and we'll want to know what their over-the-counter derivative positions are. Sometimes the discussions will be qualitative and not quantitative. If we have heightened concerns, we may ask for quantitative information verbally. And if we have particularly heightened concerns, and oftentimes that's focused around the delivery period in the futures contracts, we may actually issue a special call to get a written response to our concerns. And that additional information helps us formulate an opinion on the trader's activities and then apprise you as a commissioner.
And those special calls for that additional data can be done with staff authority, or that has to be done with commission authority?
They can be done either way. The commission has the authority, and the commission is delegated to staff the authority to issue special calls.
Thank you.
Thank you. I will have a statement for the record, but I do support position limits, the publishing the proposed rule and position limits. I'm just going to summarize one thought. As I think some other commissioners said, the Commodity Futures Trading Commission does not set or regulate prices. Rather, the commission's directed to ensure the commodity markets are fair and orderly to protect the American public. That's the core, and of course there's much that goes into that, including transparency initiatives and anti-manipulation and anti-fraud. But one piece of it, since the 1930s, has been this authority to set position limits. And in the past, the agency has sought to ensure this through a concept that there's a broad group of market participants or a diversity of views within the market. That's been at the core of promoting integrity in the marketplace, and it's at the core of why supporting proposing this. We, in fact, in the 1980s and 1990s had position limits on many of these markets. We still have position limits in the spot market. I believe on most of these 28 markets, there's one or two maybe that we don't. I'm not entirely sure why, but with regard to the all months combined, this is a proposal to, in essence, reinstate some position limits in the energy and the metals markets, and I'm looking forward to the public comments on it. But I'll be supporting the proposal moving forward and very interested in public comments. But if there are no further questions, I think, Mr. Staywick, you get to do what we almost did on December 16th.
Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton? Commissioner Chilton?
Aye, Dave. Aye.
Commissioner Chilton, aye. Commissioner Summers?
No.
Commissioner Summers, no. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
with that, I want to thank the position limit team for their return. We'll be looking forward to seeing you, I know, in the future, not only on this rule, but also on the large trader reporting rule that we're still have out for comment. And we'll be sending this to the Federal Register based on that vote. Thank you, and if Ananda and Sarah and the business conduct team want to come up, that'd be great. Today's presenters, it feels like Sarah, you're back here every so often, but Sarah Josephson and Ananda Radhakrishnan, both from the Division of Clearing and Intermediary Oversight. They'll present the staff recommendation on proposed rules related to documentation requirements for swap dealers and major swap participants. We usually call you the business conduct standards, but this one specifically is documentation. So thank you, Sarah and Ananda, and why don't I turn it over to you?
Good morning. Today, staff is recommending for the Commission's consideration a notice of proposed rulemaking with regard to internal business conduct standards for swap dealers and major swap participants. The two proposed rules would be promulgated under new Section 4SI of the CEA. This section requires swap dealers and major swap participants to conform with standards prescribed by the Commission that relate to the timely and accurate confirmation, processing, netting, documentation, and valuation of all swaps. At the last open meeting on December 16th, the Commission considered proposed rules regarding confirmation, portfolio reconciliation, and portfolio compression under Section 4SI. Today, staff is recommending two rules pertaining to swap documentation under the same statutory provision. Documentation of swaps is a critical component of the bilaterally traded over-the-counter derivatives market and has been the focus of significant domestic and international attention in recent years. The proposed regulations would require each swap dealer and major swap participant to establish policies and procedures designed to ensure that prior to or contemporaneously with entering into a swap, both counterparties agree in writing to all terms governing their swap trading relationship, including, among other things, terms addressing payment obligations, events of default, transfer rights, and governing law. The swap trading documentation would also include credit support arrangements, including initial margin and variation margin requirements and custodial arrangements. The specific rules on those provisions will be have been considered for custodial arrangements already by the Commission and for margin in future rulemaking. The documentation would also include an agreement on the methodology by which counterparties will value each swap in their portfolio at any time from execution until termination of the swap. The agreed-upon methodology would be required to be complete and independently verifiable and include alternative methods for determining the value of the swap in the event that one or more inputs to that methodology are unavailable, such as during times of market stress or illiquidity. The regulation would also require swap dealers and major swap participants to notify the Commission of any valuation disputes that have not been resolved within set time periods. This provision corresponds to the portfolio reconciliation rule that the Commission proposed at its last meeting, and which would serve, and the portfolio reconciliation serves to identify valuation disputes. This would just require reporting to the Commission. For those swaps that are cleared by a DCO, a swap dealer or major swap participant would be required to create a record indicating that in accordance with the rules of the DCO, the original swap is extinguished and is replaced by equal and opposite swaps between the clearing members and the DCO. The regulations would require that all terms of the cleared swap conform to templates established under the DCO's rules. This provision mirrors a similar provision that the Commission agreed to in the DCO risk management rules considered on December 16th. Finally, proposed Rule 23504 would require an annual audit for the swap trading relationship documentation to ensure compliance with Commission rules and internal swap dealer major swap participant policies and procedures. Turning to proposed Rule 23505, this provision would require swap dealers and major swap participants to obtain documentation from any counterparty seeking to exercise its rights under the end-user exception from the mandatory clearing requirement under Section 2H7 of the CEA. For swaps subject to a mandatory clearing requirement, the proposed regulation would require that swap dealers and major swap participants comply with any mandatory clearing requirement by obtaining documentation sufficient to provide the dealer or the major swap participant with a reasonable basis to believe that its counterparty meets the statutory conditions required for claiming the exception to the mandatory clearing requirement. This provision is important because it will fall to the swap dealer or the major swap participant to report the end-user clearing exception claim to a swap data repository, and absent the end-user's proper invocation of the exception for mandatory clearing, the swap dealer, major swap participant would be required to otherwise comply with any clearing mandate that the Commission were to issue going forward. I would welcome any questions at this point on the two proposed rules.
Thank you, Sarah. I entertain a motion to accept the staff recommendation on the documentation rule.
So moved.
Second.
In addition, before taking questions, I'd like, there's an issue concerning Title II of Dodd-Frank and the Federal Deposit Insurance Act that the Commission will consider at a future meeting. And to that end, I ask unanimous consent to revise this proposal consistent with the Commission's intention to take up these matters at a separate meeting. Not hearing any objection, you'll revise to make sure it's consistent with that, Sarah. I have support for this proposed rulemaking. I think it establishes very important swap trading relationship documentation requirements. And for many of the people, the public who have read any of the books, there's so many of them on the 2008 crisis, you may recall that part of the crisis became so evident in 2007 and 2008 when these derivatives contracts that a large insurance company, AIG, entered into, there were valuation disputes. There were great disputes on what was the value of these contracts in a rapidly changing market environment. I think the rule that we put in place, proposed today, subject to public comment, directly addresses some of these issues, that it mandates that parties like AIG in the future, hopefully there's never an AIG that brings taxpayers to the heels as that did, but that they have to have documentations and have to have ways to value their contracts, and where they have disputes with others, they have to be elevated to senior management and elevated to the regulators. But I want you to confirm that that's what this does.
Yes, that is correct. It requires that the two counterparties agree ahead of time on, and I'll read it, the methods, procedures, rules, and inputs for valuing the swap. So they have to agree ahead of time on the valuation methodology, and if there is a failure of an input to that methodology, they have to agree on alternatives so that they can value the swap going forward. And then under rules that were previously proposed, the duties rules for swap dealers and major swap participants, they would have to alert that their senior management to valuation disputes, failures to understand current exposure and potential future exposure that are usually based on disputes regarding valuation. And so it works together with that rule, the portfolio reconciliation rule, which is a process by which counterparties can identify valuation disputes and then work to resolve them. And the burden is on those counterparties to identify them, resolve them, and report them to the Commission and the prudential authorities if those swap dealers or major swap participants are
Sarah,
banks.
this is for those swaps that may stay bilateral, correct?
Yes.
They don't have the benefit of central clearing. They're customized swaps. But if an AIG circumstance happened again, number one, they have to have an agreement on how the methodology to value the swap. Is that correct?
Yes, that is correct.
And two, if they can't agree during the 10 years that a swap's outstanding, then they have to highlight it to senior management under a separate proposal, correct?
Correct.
And they also have to share it with the regulator.
Exactly, and I'll just refresh everyone's recollection on the portfolio reconciliation rule for swap dealer and major swap participant trades with each other. They have to resolve that. The proposal is, and we'll get comment back on this, is to resolve that dispute within 1 business day, and for disputes that arise between swap dealers, registrants of ours, and end users, they're to resolve those in a timely fashion.
Sure. But the swap dealer to swap dealer disputes were the heart of that. The narrative from 2007 and 2008, the big disputes were between these big swap dealers. They went unresolved and sometimes unreported to senior management.
Exactly, and those losses can be allowed to accumulate, and that could give rise eventually to systemic risk.
Right,
And so
all
the
right.
failure to value that.
So-
And your contrast with clearinghouses is important, because with clearinghouses, you arrive at a settlement price every day, positions are marked to market, and they collateralize the potential future exposure using initial margin.
All right. I thank you. I just wanted to highlight, I mean, to me, that's an important piece, and it relates directly to the crisis that we unfortunately lived through. Commissioner Dunn?
Thank you, Mr. Chairman, and I think you did point out one of the most salient issues here, and I appreciate the hard work that the staff did in this. And this was difficult because this isn't all within our bailiwick. It took a great deal of reaching out to other regulators, other entities. And Sarah, could you just kind of describe what you did in that process and how many people were involved in coming up with this final proposed rule?
So as I've mentioned in previous presentations to the Commission, we've worked very closely with other U.S. Authorities, including the Federal Reserve Bank of New York, the Board of Governors, the FDIC, the OCC, and the SEC to craft these rules. And indeed, much of the documentation work and the standardization process that has been described in the preamble quite extensively stems from the work that the supervisors of what's called the Group of 14 Dealers has been working on since 2005, really when they identified the back office concerns, including crucially documentation. And this is in the prior proposal that the Commission considered on confirmations. The number one trigger was the failure to confirm individual swap trades. And so when crises arose with Bear Stearns, with Lehman, they went in and the back office was perhaps in some degree of disarray, and that led to problems with the winding down or the transfer of those positions to solvent or potentially solvent to new parties. So we've been working very closely with U.S. authorities, with market participants who've been part of that process to address very real and recognized concerns in the industry.
Sarah, I think that the staff also took a great deal of concern to ensure that there wasn't an excessive burden on this reporting. And I think the industry appreciates that. I'm worried about the excessive burden then our staff will have in bringing this all together and being responsible for having this overall view. Are we ready, capable, and able to do that?
We are ready, we are capable. I cannot answer your last question because, as you pointed out, we've been charged with executing tremendous responsibilities, the whole agency. And it just, as a taxpayer, and I'm sorry to be on this high horse, but I'm just appalled that our elected representatives would give us this responsibility and not give us the money. I don't know how to explain it. So, coming down from my high horse, I'll answer your question. I think what we will do is we will have a discussion with the National Futures Association, because one of the proposed rules is for all registrants to register with the National Futures Association, and then make a determination as to who will have primary responsibility for examining swap dealers and MSPs. I know that the continuing resolution is supposed to end sometime in March, and it remains to be seen whether we will be funded at 2010 levels or whether we'll get more money. If we don't get extra money, and so far I personally have no reason to believe we're going to get more money, then I think the National Futures Association will have to bear the brunt of examination. It's no secret to them because I've already alerted them to the possibility. Having said that, it would be unfortunate if Commission staff did not go along with them purely to understand the operations of these new categories of registrants that we have. The worst situation would be is if you have 200 to 300 new registrants and Commission staff has no view, no understanding of the application or the execution of Commission regulations. So what I'm saying is I'm prepared for the worst. The NFA has the ability to assess fees, which we don't, and they are going to have to ramp up. And we'll probably go to the largest swap dealers first, examine them. I want to make sure that staff has an understanding of what it is we do. And at the same time, we will be collaborating, the NFA and CFTC staff, on designing the examination program, because the examination program of necessity has to be based on the final regulations that the Commission promulgates.
Ananda, thank you for your unabashed and unvarnished answer.
Thank you, Commissioner Chilton. Commissioner Summers. Sorry, Commissioner Dodd.
Thank you, Mr. Chairman. I have a couple of different questions just to clarify from the proposal. There's a piece in the proposal that talks about swaps that will be cleared and those contractual agreements having to be conformed to meet the DCO's rules. And I was wondering if you could walk through an example of that for us, to give us an example of what terms of a documentation would have to be changed or conformed to meet a DCO's rules.
Yes, so this process actually happens right now, and it just clarifies that the bilateral swap is extinguished. So this is for swaps that are not executed on a DCM or futures contracts executed on a DCM. So the original swap is extinguished, but between the two bilateral counterparties, and the clearinghouse novates the contract so that there are two equal and opposite swaps with the counterparties. And this is the quintessential clearinghouses become the seller to every buyer and the buyer to every seller, if I got that right. And so they're replaced by equal and opposite swaps, and this creates a level of standardization. The example that when they move CDS into clearing, one of the prerequisites, and this is discussed in the preamble, is that they had to standardize the products. This was the big bang and the small bang that the industry engaged in, and that facilitates fungibility within the clearinghouse so that these swaps, in the event of a default, can be terminated quickly or transferred to a liquid or a solvent FCM or swap dealer, depending on how that default situation would be handled by the clearinghouse. So it makes very clear that the clearinghouse documentation is what prevails over the bilaterally negotiated contracts between the two counterparties.
And also, Commissioner Summers, this will ensure that the terms of once clearing takes place, that the terms of the contract are the same throughout the chain, meaning that the contract between the clearing member and the clearinghouse is exactly the same as the contract between the client and the clearinghouse. Because staff believes this is essential to make sure that client clearing actually has a chance of success. Because what would be unfortunate is if in actuality, the terms of the contract between the client and its intermediary are different from the terms of the contract between the intermediary and the clearinghouse. As you know, that does not happen in the futures space right now.
Thank you. My other question is with regard to standardized documentation that exists today and whether or not this proposal would impose substantive changes to that kind of documentation that exists today and what we do with existing agreements.
So we've been very careful in crafting the proposal, and the preamble mentions all of the work that has been done by the industry, particularly ISDA, with regard to standardizing the master agreements and the master confirmation agreements. So the relationship documentation between two counterparties that allows them to execute individual transactions, and then the documentation upon which those transactions are based. So master confirmation agreements, the protocols that have been put in place for credit default swaps, they're working on proposals right now for equity derivatives to standardize terms. There's a tremendous amount of work being done, and most of that done by ISDA in conjunction with, as I mentioned, the OTC Derivative Supervisors Group, the group that has been in place since 2005. We've tried to be consistent with that to the extent that that documentation meets the requirements. And again, we laid out broad parameters for what our expectation is for those documents, but we didn't prescribe the actual documentation. So they can continue to use those. There may need to be additional amendments to reflect the overall reform and certain provisions that we view as, this is particularly the case with the collateralization elements, that they have master agreements, credit support arrangements, usually with ISDA it's called the credit support annex, and those may have to be modified by amendment, but for the most part, we think that the documentation will work together, and so those two processes are on parallel tracks, with the goal of being as consistent as possible, and this would be applicable on a global basis.
And so just to clarify again, they may need to be modified going forward in the future, or they may need to be modified looking backwards.
So there's two things. An existing master agreement between two counterparties is usually in place for a number of years. You execute one of those and they stay in place for a number of years. Amendments to those for swaps executed under it going forward is that would have to be done for, and this is where in the proposal you'll see there's we ask a question about dormant trading relationships. So if you have documentation in place but you're not executing swaps under it, you don't have open positions under it, or they're going to expire in a very short term, then it wouldn't have to apply to that. But for the transactions that you execute going forward, swaps that are subject to CFTC jurisdiction, then the provisions we anticipate would apply, but that's where we've solicited comment from the industry, and we are very hopeful that we'll get good comments on the application of these rules to the current practices.
Thank you.
Thank you, Commissioner Summers. Now, Commissioner Chilton.
I have no question to thank the staff. I support the rule. They've done good work. Thank you.
Thank you, Commissioner Chilton. Commissioner Amalia.
Thank you. We had a proposed rule language before us yesterday that was provided by the FDIC to the Commission in the 11th hour that was an attempt to give two regulators, the CFTC and the FDIC, the ability to take control for 24 hours of the uncleared swap positions of all swap dealers and major swap participants when there was a defaulting counterparty. Mr. Chair, and I appreciate your willingness to remove that language from the proposal so we can vote this morning on our documentation rule and give us more time to understand the ramifications of that proposal. I appreciate that very much. That's part of the reason we have changed this proposal. I just have one question. The proposal discusses providing alternative methods of valuation. What do you think that might include?
Alternative methods, particularly with regard to inputs, you have to agree. For instance, if there's a illiquidity in a particular asset class or a reference that you need to use to value a particular type of swap, that you would agree ahead of time, all right, if we're not going to rely on, for instance, an interest rate curve that's this one, we'll rely on this interest rate curve instead. It's to address the issue of parties saying, you know what, the mortgage-backed securities market or municipal bond market, there's been some sort of illiquidity. We no longer have that data point, so we just can't value the swap on our books. And so instead, we're asking them ahead of time, think through those possible scenarios, especially if you're doing a structured, very unique, customized product, and agree ahead of time between each other in a private contractual relationship on how you will substitute a methodology and input a rule to arrive at a value, again, with the fundamental point of, in order to understand what your current exposure is to your counterparty, this is again bilateral, uncleared, or the potential, if you had to replace that contract, if your counterparty were to default to you, you need to know that risk. And the fundamental building block of understanding the risk is knowing what the value of that contract is in a current mark-to-market way.
What is our responsibility in kind of overseeing that alternative these valuations?
So in the provision, it says that these rules shall be stated with specificity necessary to allow the counterparties themselves, the commission, and any applicable prudential regulator to determine independently in a substantially comparable manner. So how this would play out, I think, is if we see through the reporting of these valuation disputes, and generally what happens in a valuation dispute situation is there's uncollateralized exposure. That means that the parties have not exchanged collateral based on a potential risk. And so we would be notified of that. We could go to the industry, because it would have to be a significant amount of accumulated risk in the system, and we could say, let's look at your documentation. How can we solve this? What isn't working in your dispute resolution processes, that is allowing this uncollateralized exposure to build up?
Is the process any different? Will we use a different process in terms of a crisis? Looking at these things on a bright sunny day and the markets are functioning very well is a completely different matter than when we're in a crisis like we experienced with AIG and Lehman.
Right. The hope is that these type of provisions will, in the first instance, facilitate counterparties resolving this between themselves before it even comes to the attention of the regulators. So if they resolve the disputes under the portfolio reconciliation proposal in a timely fashion, then there is no uncollateralized exposure. It will allow us to ahead of time, hopefully, identify exposure in the system and work with the industry to resolve those, to get that sorted out. And should it be allowed to continue, or for there to be a failure to recognize that in time to stop it from becoming a true crisis like we saw in 2008, these processes will allow, and the documentation that will be executed between the counterparties will allow for an orderly wind down. That's the hope, and that was the provision that you mentioned under Title II and the Federal Deposit Insurance Act, is to allow that sort of concept of an orderly wind down, transfer of positions to avoid market disruption. So they work together in that way, hopefully.
Assuming Enron Online was a dealer, would we have stepped in with this new authority and kind of resolved when it went into bankruptcy?
I'm not sure whether the issue with Enron, are you saying the issue with Enron Online was they did a lot of swaps and there were improper valuations?
When it failed, there were a number of counterparties that were impacted by that.
Sure.
And
I'm not familiar with the facts of the case. I thought Enron Online, Enron problem was because there was just massive fraud outside of the trading engine, but are you saying there was?
No, but when they ultimately failed, would we have stepped, under this new authority,
Yeah.
would we have stepped in and had the responsibility in that bilateral space to resolve those transactions?
I would say yes. If this rule is finalized, I don't see how we cannot step in because it's our registrar.
Can I give it a try? As I understand the hypothetical is if it's a swap dealer, whether it's Enron
Yeah.
or if it's a swap dealer that we regulate, would we have the authority? I'm changing the question a little bit. Would we have the authority to do things? And as I understand it, this is just, this rule is a little narrower than that. This rule just makes sure that if there are these big valuation disputes, they have to tell us about it. But this rule specifically doesn't necessarily give us the stick. There may be other rules that do, but this rule doesn't. Is that?
Well, it's going back to this, what was originally in this document, and what I'm trying to understand, is that in Title II?
Right, I can try to clarify that. So the idea behind that provision, which will be considered in potentially a future discussion, is that there would be in the documentation of the swap dealer and the major swap participant a one-day delay in the termination, their ability to terminate under that contract, to allow if a U.S. authority under Title II or the FDIA had made the affirmative decision to enter into that scenario to wind down the entity in an orderly way. So it's an affirmative decision by U.S. financial regulatory authorities to step into a situation where there's a crisis that is clearly of a scope that would be a systemic shock to the overall markets. But that is and the participation under that process, this is why we have a little more time to work through the section, the provisions under Title II, which is a new section of Dodd-Frank, obviously, and then the similar provisions under the FDIA.
Let me go to one last question. In resolving some of these disputes, do we have the authority to make decisions about the quality of collateral?
Under these rules, that is not that's not something that we are weighing in on. That may be, what we say is the types of assets that may be used as margin and the asset valuation haircuts. So the parties have to agree on the types of assets between each other that can be used to margin the swaps, and then the haircuts imposed, which usually goes to an assessment of the quality of the collateral. But that is, in the first instance, an agreement between them on that, which will be guided by rules to be proposed in the future by this commission, and for those entities that are banks, by prudential authorities under their regulations.
How are we going to inform the market of what we view as quality collateral versus less quality collateral, just so they have an understanding of what the rules are going forward?
Right. I believe that those proposals will be considered by the commission in a future rulemaking, or the staff will be proposing them at a later point. This
will
rulemaking
be
doesn't.
part of the margin, capital margin.
And to clarify, because I think this was very helpful questions, most of the authorities with regard to, in fact, I think all the authorities with regard to bank holding companies or large financial institutions, if anybody's going to take, a wind down or anything like that, that's not this agency. That's the bank authorities and the FDIC. Your Enron example was a non-bank, so that's.
So they don't get that protection?
What's that?
They don't get that. I don't know if it's a benefit or a curse to have the feds involved, but at this point, because I don't know that title very well, but is that how?
As I understand it, I don't want to, maybe if Dan wants to or somebody else, but as I understand it, Title II really goes to bank holding companies and systemically important large financial companies that are, identified by the Financial Stability Oversight Council and so forth. So if, not to suggest that a swap dealer we regulate would not be large, because it's possible, but if a swap dealer we regulate because it's not a bank, it's probably not going to be one of those entities either. Is that, as I understand it?
Yes, I think generally speaking that is correct, and this will be, we'll get some more information to you on this, but for covered financial companies, right, which is under Title II, that regime, if a swap dealer that was not a bank, and again, we'll verify all of this, but my understanding is if they're making 85% of their profits or more from swap trading, then they could be considered a financial company that under Title II could be a part of this orderly wind-down process that is contemplated. But again, we'll follow up with additional information for you on that topic.
Thank you. If there are no further questions, Mr. Staywick.
Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you, and we'll send that to the Federal Register as well. I think I already asked a UC on this FDIC thing, but just in case you have other technical provisions, at this point, I ask unanimous consent to allow staff to make technical corrections to, and I'm only asking it for this because the position limit one is already done, but just UC in case Sarah's got to just make technical corrections. Without objection, and that's so moved. As you know, we've identified 30-some topics for our rulemaking. Our next meeting is going to be on January 20th, 1 week from today. And the subjects of the rulemaking presented at that meeting will be published on the Commission's website, I guess today, sometime. And as I said earlier, I think that we're going to have a couple of meetings in February, but we'll address the dates of those meetings next week. On January 20th, we'll vote on the dates. There being no further business, I'd entertain a motion to adjourn the meeting.
So moved.
Second.
All in favor? Aye.
Aye.
The ayes having it, the meeting is adjourned. Thank you so much. Congratulations on 25 years again.